Okay, well, today is Monday, May 11th. Happy belated Mother's Day to all of the mothers on the phone. Let's talk about what happened over the weekend since we were last together on Friday. The statistics globally, 4.1 million confirmed cases of COVID-19, 282,000 deaths. In the United States, we are up to 1.3 million confirmed cases of COVID-19 and 79,525 deaths. Here in Michigan, the numbers are 47,138 confirmed cases, 4,551 confirmed COVID-19 deaths. If there is good news in any of that, and it's hard to find good news when we're talking about people's friends and family members passing away, yesterday was the lowest number of daily deaths and the lowest number of new confirmed cases. So the trend is looking good. Although I will say, this is just my own side comment, on Sundays the numbers do tend to be lower. I think there's just, for whatever reason, less people working and reporting these things. So I always wait until Monday and Tuesday. Often the numbers go up slightly. But if you've been reading the news, people were pleased that yesterday the numbers were trending way down, second lowest point since March. Michigan received 1,600 vials of coronavirus drug remdesivir from the U.S. government to begin a more active treatment using that drug here in Michigan, so we hope that will be helpful. The Michigan Restaurant Association sent a roadmap to Governor Whitmer for how they think they can reopen safely. They're pushing to reopen sooner rather than later. As many of us know, particularly if you're a manufacturer on the phone, manufacturers are permitted to reopen this morning, subject to a number of qualifications. The U.S. employment rates spiked to 14.7% in April. The economy lost at least 20.5 million jobs. These are the largest numbers since the Great Depression. All of you on the phone have some relationship to human resources in your organization, so that is probably not a surprise to you. And lastly, in Wuhan, they reported their first symptomatic coronavirus in more than a month. They had gone a month without any virus at all, and now there's a small pocket that is back. So that is the news that you may have missed over the weekend while you were celebrating Mother's Day. Today we're here to talk about the Fair Labor Standards Act and questions we have been getting from many of you. We thought we would share those answers with the group so that everyone could benefit. Also, since the last time we gathered for a webinar about the Fair Labor Standards Act, the Department of Labor issued a frequently asked question document about how COVID-19 relates to common Fair Labor Standards Act questions. And I was pleased to see that many of the facts were questions that were on our frequently asked question list as well. And I was even happier to see that the Department of Labor's answers were consistent with ours in almost every respect. So let's get at it. I have a number of questions prepared based on the frequently asked questions that we had been getting here. Two people, when they registered, asked questions ahead of time. So why don't we start with those? Because despite my best efforts, I do tend to talk more than sometimes I plan on and run out of time. So I want to make sure I get to the two questions that attendees asked. The first question that came in with the registration is this: any implications or recommended documentation for terminating an employee because there isn't enough work during this time? There is no legal requirement that you inform people in a certain way. I highly recommend that it be done in writing, that you explain whether this is a temporary situation. In other words, when work picks back up, they will be recalled. If so, in what order? You should tell them what will happen to their health care benefits during this time. And it's also good to give them unemployment insurance agency contact information. When they apply for unemployment, which they will be entitled to, right? They would qualify if they're not working because of lack of work through no fault of their own. You will have the opportunity then to confirm that that is the reason. So the employee will check off what the reason is. They will say laid off for lack of work. You will get a report from the UIA and confirm that is the reason. And then having that documentation somewhere in a letter is helpful as well. Frankly, it's also just good communication with your employee, and that is always the goal. Okay, question number 2. If someone is quarantined at the direction of the health department due to potential work contact, is this paid time? Okay, that's an interesting question, and let's break that down. The general rule of thumb, I'm going to give you 2 rules under the Fair Labor Standards Act are, first, if there is a workplace illness or injury and you direct the employee to seek medical care and they do so during regular work hours, that time is paid. Okay, are you with me? So it has to be during regular work hours at your direction. That time is paid. That's rule number 1. Rule number 2, generally the Fair Labor Standards Act does not require that time off has to be paid, even if that time off is required because of a workplace injury or illness, okay? So here, if someone has to stay home because of a potential work contact with, I'm guessing that's with someone with a positive COVID-19 diagnosis, that time off does not have to be paid under the Fair Labor Standards Act. But, right, at issue here, if you are an employer of 500 or less, you are covered by the FLSA, which is still a new federal law, even though now it feels old because we're in this weird time warp, right, where something that happened a month ago already feels old. That has 2 components. One is 2 weeks of paid sick leave, and then another 10 weeks of expanded FMLA for child care related purposes. Being quarantined at the direction of the health department, or I'll just put it a little more broadly, staying home because under Executive Order 36, whenever you have had close contact with a positive COVID-19 case, you are supposed to stay home for 14 days. That would qualify for the sick time, that 2 weeks of paid sick time under the FFCRA, okay? So that could be paid sick time. It could possibly also qualify under the Michigan Paid Sick Leave Act. So if you are an employer under 500, almost certainly that will qualify for paid sick time. For the rest of you that have 50 employees or more, it may count under Michigan Paid Sick Leave. And so those are the questions we got before the presentation started. Now let's get into the frequently asked questions that we have heard here at Miller Johnson. Okay. Question number 1. We laid off employees. Now some want to volunteer for us. Is that okay? The answer is my favorite lawyerly answer. It depends. If you are a for-profit company, okay, you cannot have people come volunteer for you, okay? And that, by the way, is the very first topic on the DOL's Q&A, so I have a feeling they've been hearing about a lot of this, okay? You generally, if you're for-profit, there's no such thing as a volunteer, okay? You have to pay people for their work. If you are a not-for-profit organization, can people volunteer for you? Generally, people from outside of the organization can come in and volunteer for you to perform civic, religious, or humanitarian objectives. But be very careful when it's your own employees, even those who have been laid off, who want to come back and volunteer for you. Generally speaking, employees cannot volunteer for an organization performing the same type of work that they get paid for. Okay, if you have specific questions about that, let me know after the presentation. If it's the exact same job duty, they probably shouldn't be doing it. If it's not the exact same but similar, that's where we have to have a conversation. If the classic example, which doesn't fit the current scenario at all, is a hospital nurse who wants to volunteer at a registration table at a marathon that the hospital is sponsoring on the weekend. That would probably be okay because registering runners for a marathon is nothing like being a nurse. However, if that same nurse wanted to volunteer giving vaccinations, for instance, in low-income neighborhoods, and want to do it at a volunteer basis, that would be much closer to our regular job duties and would probably not be okay. All right. Question number 2. Leaders want to reduce each employees per week to save on payroll instead of laying off more employees. So they want to reduce how much each employee is working per week. Can we pay employees less if they work a partial week and thereby not laying off as many total employees? The answer is going to start off, first of all, with probably part of an answer I'm going to give to every single one of the rest of the questions, which is let's assume there's no union contract or employment contracts. Okay, once you have a contract in place, you have to do what the contract says. So assuming there is no contract at issue, non-exempt employees, yes, you can reduce their weekly hours and then reduce their pay. Not a problem. The employees may not be happy, but it's perfectly legal. Exempt employees, as most of you on the phone probably already know, are a different situation. The general rule for exempt employees is if they work any part of a week, they must be paid the full week. Okay, so that is not going to help you with exempt employees necessarily. Although that brings us to our next question, which is, can we require exempt employees to take PTO during times we are closed or when we are open? Can we require exempt employees to take PTO? And let's finesse that a little bit. Can we require employees to take PTO for those partial weeks, right? I want to combine this with the last question, for those partial weeks. Let's just say Friday. Let's say you want your exempt employees to work Monday through Thursday, take Fridays off, and use a PTO day for every Friday. We have advised clients, and the DOL has now confirmed in their Q&A that that is okay, because the Fair Labor Standards Act does not differentiate between regular pay and PTO pay. Now, of course, the rest of us do, right? All of us that live in the real world, that's a heck of a big difference, whether you're using PTO or not. People watch those banks more than they do their actual bank accounts sometimes, I think. But according to the DOL and the Fair Labor Standards Act, that makes no difference. As long as the salary is the same, let's say someone gets an $800 salary every week, and 1 week you say, okay, employee, you're only going to work Monday through Thursday, so 4 of those days will be your regular salary. You're still going to get that $800. Your paycheck will look exactly the same, except for Friday, we're going to dig into your PTO bank to cover that last day. The Department of Labor has no problem with that. Can you do that on a full week basis? Yes. Can you do that on a partial day basis? Yes. Okay. You can require exempt employees to take PTO during times when you are closed or even when you are open, but you want them to work partial weeks. Okay. What about leave without pay? Can you require exempt employees to take leave without pay? Yes, but if they work a partial week, then they have to be paid for the full week. So if you want employees to take leave without pay, you should do that on a week basis. For instance, some employers might do a week on, a week off, or 3 weeks on, 1 week off, that sort of thing, if you want it to be without pay, even without PTO pay. Okay, next question. Can we ask an employee to perform work outside the employee's normal job description? This is something we've been seeing quite a bit as employers try to get work done with fewer employees, and employees have to multitask a little bit more. The answer is, if there is no contract, then yes. You can always ask an employee to perform work outside of their employee's normal job description. For non-exempt employees, frankly, there's very little risk from a legal standpoint in doing that. The challenge will be the practical, what wage rate will they earn? If the job duties they're temporarily assuming are at a higher or lower wage rate than the regular wage rate, what are you going to do about that? There are no legal requirements. That is a employee relations issue for you. For exempt employees, you can also always ask an exempt employee to do work that is not their usual job, but be sensitive to the issue of the primary duty test, right? Now, we're going to go back to something us wage and hour lawyers talk about a lot, which is, whether someone qualifies to be exempt or not. And if you've heard me speak at all, I've said this a million times, right? So to be exempt, there's two qualifications. One is you have to make at least the minimum salary required by law, the same salary every week. And the next is your primary duties have to be exempt duties, okay? So if you have an exempt employee who normally performs exempt duties, but now you want them to work back on the line because maybe at one point they did work on the line and then were promoted up, but now you don't have enough employees on the line, so you're going to reallocate your resources and you want this person to go back on the line. That person would most likely lose their exempt status for the time period they're working their line because their primary duties are no longer exempt duties. Okay, if you have, again, contact me after the presentation if you have specific questions about a specific employee that you are curious about. But that is the rule with employees performing different job duties. Okay, next question. Can we require an employee to work from home? Now, let's just assume this is an employee who actually would rather come into the office. By the way, they're pretty much describing me. Because I worked in the office until the last day, until Governor Whitmer actually said I couldn't, and then I was required to work from home. And the second I can get back in or find any argument to get back in, you better believe I'll be there. So I sympathize with this. So you have an employee that would rather be in the office. Can you require them to work from home? The answer is yes. You can require an employee to work from home whether or not they want to. Now, I want to take this a little bit farther. Now that more employees, more facilities rather, are opening back up, we're kind of in the phase of, the last month we were in the phase of slowing things down and shutting things down. Now we're all in the phase of ramping things up. Can working from home be a reasonable accommodation? So what about an employee that you would rather have be in the office, but the employee asks you if they can continue to work from home, and let's say that reason is because they are at higher risk for severe illness if they develop or if they catch COVID-19, and the CDC has a whole list of conditions, right, that can make you more susceptible to severe illness if you contract COVID-19. The EOC has issued guidance on that, and it's clear, frankly, even before their guidance and certainly after their guidance, that yes, that can be a reasonable accommodation that you need to consider if you get a request like that, okay? And then you go through the interactive process as you normally would. You can request information from the employee's physician to confirm they have a condition that puts them at higher risk. The EOC says that you can consider other accommodations as well. Remember, in the accommodation world, the employee suggested accommodation doesn't have to be the accommodation that you ultimately land on, right? You can consider other reasonable accommodations that would solve the problem. The EOC puts out a number of examples of other accommodations, safety equipment, distancing, frankly, many of the things that are required now anyway for in-person operations, at least in Michigan, that can also be a reasonable accommodation in addition to the person working from home. So that is the situation for folks working from home. We're going to go through a few more questions about working from home because obviously that's a big topic right now. Do we have to pay employees the same hourly rate or salary if they work from home? No, you don't. Now, again, this could be an employee relations issue, so tread lightly, but legally under the Fair Labor Standards Act, and again, assuming there's no contract that provides otherwise, you can change the rate of pay for people who are working from home, okay? Conversely, you could keep their pay the same, but increase pay for people that are coming to work in person, okay? Another offshoot of this question is people working from home may not be working as much. It might be because you don't have as much work for them to do. That's frankly a common situation, not because the employee wouldn't work if they had the work. If they had the 40 hours, they do it, but customer demand has dried up and other things, and so there just isn't 40 hours of work to do right now. When employees, non-exempt employees are working from home, you only have to pay them for the time they're actually working. You can adopt a timekeeping system that works for you. It might not be the same one you use in the office, particularly if you have a time clock on the wall or people scan their badges when they come in. It might be just a typed email once a week or an exception method or something along those lines. But you can keep track of the actual hours they are working and just pay them for that time. If they are exempt employees, of course, any amount of time they work during the week, if they work any amount of time, they have to be paid for the full week. Okay. Do we have to pay employees who are not able to work from home? Right, now this is a little more difficult question. If your business or facility is shut down for in-person work, except maybe one or two people doing payroll and opening the mail, and you say everyone has to work from home, and someone says, but I can't, right? I don't have a quiet place. I don't have internet where I live. I don't, whatever the situation may be, do you still have to pay them? This is tough, but the answer is no. And the Department of Labor answers that straight. They encourage you to consider other options to get the person to work in the facility so that they can still maintain their employment. But the reality is here in Michigan, with the strict orders we're under, that just may not be possible, okay? So you only have to pay people for when they're actually working. If they can't work from home, they're not actually working, and therefore they do not have to get paid during that time period. Let's talk about temp agencies for a moment, temporary employees. This is particularly, I think, relevant to our manufacturing employees or employers who are starting back up and need a certain volume of employees. And for various reasons, and I won't go through them all right now, you may have trouble getting all of your employees back to work. So if you are in the situation where you need to bring temp employees on from a staffing agency, are you liable under the Fair Labor Standards Act if they are paid incorrectly? All right, I want to talk to you about two things about this question. The first is there is a new rule, a new regulation that became effective March 16th, 2020. Now that was just as where all the COVID-19 stuff started hitting the fan, if you will, here in Michigan. And no one was paying a whole lot of attention to this on March 16th. We did send out an alert or two before that, and you probably saw it if you're in SHRM or other organizations before March 16th, because it became final the end of December, even though it didn't become effective until March 16th. The new rule, which was meant to simplify the test for joint employment, is as follows. Okay. You are a joint employer with the temp agency. if you have the authority to do the following, and it's a balancing test of the following 4 factors: hire and fire the employees, supervise and control the employees' work schedules and conditions of employment to a substantial degree, determine the employee's rate and method of payment, and maintaining the employee's employment records. Okay. The DOL says that there may even be other factors that could be relevant in an individual situation, but these 4 will always apply, and it is, again, a balancing test. So even if one doesn't apply but the others do, and strongly, you may still found to be a joint employer. That term joint employer is really important, because if you're a joint employer, it means you're just as liable as the other joint employer for Fair Labor Standards Act violations. The general concept here that you should always have in mind is that one employee can be employed by more than one organization at a time. And when that happens, it's called joint employment. So some temp workers have more than one employer. They have the temp agency and they have you, okay? So it's always helpful to give as much control to the temp agency as possible, right? Those 4 factors, you want to the extent you can, give the temp agency the authority to hire and fire the employee, to determine the pay rate, to maintain the employee's employment records, et cetera. Most likely you're going to supervise the employee's work because they're on your work site, right? That would be extremely unusual for you not to have any control over the conditions of employment or the work they're actually doing. The DOL is clear that you cannot enter a contract that predicts the outcome of this test. So in a contract between you and a temp agency, you cannot agree that the temp agency will be the sole employer and you will not be considered a joint employer. You are welcome to write that into a contract if you would like, but the DOL will not look at that and say, oh, okay, well done, that answers our question, right? Inquiry ended. That's not the way it works. Now, another reason I wanted to bring up the concept of joint employer is under the FFCRA, which I already mentioned towards the beginning of this webinar, only certain employers are covered by that act, by the FFCRA, and it's employers of 500 or less. Okay, so counting employees correctly is important, particularly if you're near that cutoff mark. And how do we count employees? This is how the Department of Labor and the regulations implementing the FFCRA has said the employer should include full-time and part-time employees, employees on leave, temporary employees who are jointly employed by the employer and another employer, and day laborers supplied by a temporary placement agency. Okay, so those categories of employees are counted for FFCRA purposes. If those employees put you over the 500 employee mark, you are no longer covered by the FFCRA. That cuts both ways. Some folks may be relieved that they're not covered by the FFCRA because it's one less thing they have to worry about. Others want to be covered by the FFCRA because it provides for paid leave for employees that is reimbursed to them through tax credits. So it's a way to provide a benefit to employees with very little out of pocket to the employer. So that's why joint employment is important. It's always important, but it's particularly important now with the FFCRA and that language in the implementing regulations. Okay, let's go on to our next question. We are returning to work at our facility and want to bring back as many employees as possible. Can we reduce employee hourly wages from the wage rates before the pandemic? So non-exempt employees, wage rates, hourly wage rates, can we reduce them? Yes. Again, assuming there's no contract, yes, you can. Can you reduce exempt salaries? Yes, you can. But caveat there, you can't you can't manipulate or increase and decrease on a frequent basis an exempt employee's salary if it is an attempt to pay them according to how much work they actually perform. Because remember, one of the things that make exempt salaried employees unique is that they get paid the same predetermined salary on a weekly basis no matter how much work they actually do, right? So if the salary keeps going up and down based on the amount of work they're doing that week or those 2 weeks, that's a problem. If you're reducing a salary for a longer period of time, let's say there's no bright line, unfortunately, but 3 months is probably safe, right? Something like that. You're probably okay, but don't be flipping and flopping back and forth every week or two. All right. Let's talk about paying folks extra. Okay, so we just talked for a few minutes about paying people less. Now let's talk about paying people extra. We have a number of clients who are paying employees extra money who are working in person. How does that impact overtime rates? I talked about this during the last Fair Labor Standards Act webinar, and we got a number of questions about it during the webinar, and then also just from clients and day-to-day counseling matters. So I want to make sure we talk about this one more time. And also, I didn't get a chance to answer this live on the webinar last time, so I want to make sure I answer the specific questions this time. If you are paying an hourly bonus, and you can call it whatever you want, a bonus, a shift premium, an incentive payment, hazard pay, you can put whatever name on it you want, but if it's, I don't really care about the name. If you're giving folks extra money per hour, that money does count as part of their regular rate when you're calculating their overtime premium. If you're paying people extra money per week for showing up in person, that money needs to be included in the regular rate for calculating overtime. If you're paying people an extra bonus per month for showing up to work in person, that money gets calculated as part of the regular rate for calculating overtime. Now, if you are, here's the way to do it that where you don't have to recalculate things. If you are paying people a bonus, which is a percentage of their total wages in a week, you don't have to recalculate anything, because the math folks, and I am not one of them, the joke is, among a lot of lawyers, I went to law school because there's no math on the LSAT. That would certainly describe me. But the mathematicians amongst us are correct that if someone's making the regular rate and then also overtime in a week, and then you say, I will pay you a 10% premium on that, on the total of your regular wages and overtime, you're already giving them an overtime premium. The math works out. So you can do that and then not go back and count that bonus back into the regular rate. It's already, you want to think about pre-baked in there, okay? So that would be the easiest administrative way to offer a bonus for folks that are coming to work in person. Also, if folks aren't working overtime, then you don't have to be worried about any of this anyway, right? If you're light right now and there is no overtime and you want to give people an hourly bonus, that's fine. You don't have to recalculate anything because there's no overtime to calculate in the first place, okay? So that is extra pay for folks that are coming to work in person. What about COVID-19 training? Now let's talk about that for just a moment, because first of all, I just want to remind all of you that have manufacturing facilities, the executive order issued on Thursday by Governor Whitmer, it allows all of you to ramp up your operations again starting today, also requires every manufacturer to provide COVID-19 related training to every single worker. This is true for those of you that are starting up again. This is also true for those of you that have never shut down, right? Maybe you employ critical infrastructure workers and you've been permitted to keep to be operating during this entire time, you all need to provide COVID-19 related training. And now I'm going to give you my own perspective on this. I have a feeling this will be required in other industries as well in short order, right? I think they're rolling it out slowly, starting with the manufacturing facilities, but I would be surprised if this wasn't required everywhere in short order. Also, even if it's not required, even if I'm wrong on that, every once in a while, about once a year, I'm wrong on something. This might be the one time, I don't know. If I am wrong on that and it's not legally required of every worker in Michigan, I think it's a good idea, right? Because people want to know what you are doing to keep them safe when they come to work. They're inundated with commercials and social media messages and signs and neighbors and friends and everyone telling them, stay home, stay safe, right? Stay home, stay home, stay home. And now you are telling them to not stay home and to come to work. So there's some conflict there. Not all of your employees are worried about their safety, but a lot of them are. A lot of them genuinely are. And so if you can provide a short training, it does not have to be a day-long type of a deal, but a short training that explains your understanding of what COVID-19 is, which should be based on the CDC, and what you are doing at the facility to keep folks safe. That will be very reassuring to your employees, okay? Now, the Fair Labor Standards Act, part of that question is, do we have to pay employees for that time? The answer is yes, okay? You should pay employees for that training time. Again, it does not have to be a day or a half day type of deal. Miller Johnson has developed a training video, a generic training video that you can easily supplement with facility specific information. And our video is 12 minutes, and it covers all of the required aspects under the executive order. You just supplement it with your own facility rules, telling people where the hand washing stations are and that sort of thing. So we're not talking about a huge investment of time, but yes, employees should be paid for that time, okay? Let's talk about just briefly some resources available to you. The Miller Johnson Back to Work Resource Center is a subscription-based opportunity to get all sorts of forms and policies, and that training video, which I mentioned, is available there at no additional cost. So that's a good back to work resource for you that's updated once a week, which is very nice. That's me. I'm the one who is talking. Let me look to see if there are any questions. I will admit to you, I have not been looking at the questions while I've been talking, so I will take a peek now. As we are looking to reopen, we have staff who are not higher risks, but they do not want to return to the workforce. What are our options? Okay, that's a great question and definitely qualifies as a frequently asked question. In fact, I think we have, it's probably a few weeks old now, but we have a whole webinar just on that topic. If they are not higher risk, they're not entitled to an accommodation under the law, right, a reasonable accommodation. If they do not want to return to the workforce and you have work open to them, you have two choices. You can either terminate the employment relationship, or you can grant them some type of furlough status, right? And which option you choose might depend on, well, it always depends on your specific circumstances, but the type of circumstances you want to think about is, what kind of message do you want to send to the rest of your employees? How badly do you need staff right now? Employers in Michigan right now run the gamut. Some need every employee, all hands on deck right now. So this sort of thing really is unacceptable, right? You can't allow people just to basically voluntarily furlough themselves. Others, frankly, are overstaffed right now and are looking ways to cut costs and would be looking at layoffs anyway. So maybe that's a way to for people to self-select, and then you don't have to make the difficult layoff decisions. It may depend on that particular person, how badly you need that particular person and their particular skill set. The way to convince people to come to work who are nervous about it is communication, communication, communication. I talked about that a little bit with the training, but you really need to reassure people that you care about them and their safety, and this is what the CDC says you should be doing to keep people safe at work. And this is what OSHA says, you know, if you do this, people at work will be safe, and you are doing all of those things, right? So that's very important. The other thing you should know is that someone in that situation would not be eligible for unemployment. Some people don't want to come back to work because they're nervous about their safety and their health and their family's health. Some people are making a lot of money on unemployment right now, right? With the federal kicker, that extra $600, it works out to the equivalent of about $50,000 a year. That may be more than they're making for you, right? If they make $25,000 a year for you, they're going to say, can't I just stay on unemployment for another few months, right? Because I'm making more money for doing nothing. The reality is they will no longer be eligible for unemployment as of the week you have work for them to do. And you can definitely make them aware of that fact, okay? And that should provide a little incentive for them to get back. Next question. If we want an employee to come back and they decline, oh, here we go, I should have read ahead. Most likely because they're getting a lot more from unemployment, how do we handle and document this? Will this exclude them from getting future unemployment benefits? I think I just answered most of that. You should certainly document that and put that in their file. And when you get the report from the UIA, you're going to want to communicate with the UIA that there is now work available for that person. Yes, that will exclude them from getting unemployment benefits. Okay, but here's my little commentary on that. Just remember that the UIA is swamped right now. So how quickly benefits will be cut off, how closely the UIA is looking at it, I can't guarantee you, right? Because those of you that have worked with the UIA on a good day before the pandemic, they were not exactly speed demons. So now that they're inundated with claims, is it going to be taken care of the next day? Probably not, but the rules are clear. And in fact, the head of the agency did a press conference that was unforwarded, and a reporter actually asked that specific question in the press conference. This Matt is the one that asked this question now. Matt, a reporter asked that specific question, and the director of the agency said, without hesitation, that employee would not be eligible for unemployment benefits if they're not coming to work simply because they don't want to come to work if they'd rather get unemployment benefits. They would no longer be eligible. Okay, those are the questions I see. I'm going to pause for just a moment to see if anyone else has a question. And if not, we will say goodbye. Okay, I'm not seeing any other questions coming in. I hope you all have a great week and a productive Monday. If you have any questions that occur to you after this webinar, please reach out to me. Thank you very much.